Question: what's community property and what's separate property, and why does it matter? Answer: in a Texas marriage, there are basically three kinds of estates. His separate estate, stuff the hubby brought into the marriage and a couple other things. Her separate estate, the same thing. And the community estate, stuff either one of them brought or earned during the marriage with a couple of exceptions. It gets a little confusing sometimes. Separate property, think savings account the husband had before the marriage, is separate, but the income from it, interest earned for example, is community property. More potential confusion. If somebody gives a married couple, say, a vintage 72 Pontiac Firebird Trans Am with the original decals and the sweet cherry bomb muffler system, it's not community property. You see, under Texas law, you can't give a gift to the community estate, so the husband and wife are actually co-owners, with each of them owning half of the Trans Am as his and her separate property. As to why it's important, at least in the context of having a will, if the husband gives the Trans Am to his nephew in his will and then dies before the wife, he's only giving his separate property half because he can't give the wife's separate property away through his will. Since the ride's no good after you cut it down the middle with a blowtorch, somebody's probably going to have to buy somebody else's half of the Trans Am. Likewise, if we change the facts to where husband and wife bought the Trans Am as an investment while they were married, it's community property and nephew still has to share it, because the husband can only give away his half of community property under his will. All of the above to say, the character of property is separate or community is important when making provisions in a will. Consulting an attorney is one way to be confident that your stuff goes to the person you intend for it to go to.